My name is Dr. Carla Hewitt, and I'm going to walk you through the process surrounding reopening of closed medical benefits for adjusters. In 2011, sweeping changes were adopted for Montana workers' compensation in the Montana Code Annotated 39-71-704, including adoptions of fee schedules, UNT guidelines, medical status form, and the 60-month termination of medical benefits. In addition, the statute 39-71-717 allows for the reopening of the terminated medical benefits and has charged the Department of Labor and Industry to develop the process to handle the reopening of the terminated medical benefits. 39-71-717 specifically outlines exceptions to reopening. The reopening of medical benefits does not apply to medical benefits that are closed by settlement or court order, or to those who are permanent total disability, or those with a prosthesis. There are levels of evidence of proof in the legal system and are termed substantial, preponderance, clear and convincing, and beyond a reasonable doubt. Clear and convincing is the level of evidence that is typically used for criminal proceedings. Preponderance of evidence, which means a tittle or slight tilt of the scales of justice in favor of the party, or 51% of the weight of evidence. This is the level of evidence that is used in civil and family law settings. Preponderance of the evidence is the level mandated by 39-71-717 when considering the reopening of closed medical benefits. All things being equal, if the evidence presented is just 1% in favor of one party over the other, then that is the party that the decision must be made in favor of. Next, we review each of the steps outlined in the statute regarding the specifics of the petition, a medical director review only versus a panel review, who provides the medical records, and what happens in 2 years after the initial review. Medical benefits are to be reopened only under 2 scenarios. The medical treatments are to allow the worker to stay at work, or there is a reasonable expectation that the medical treatments will get the injured worker back to work. It was not envisioned, and the law does not support the reopening of medical benefits for those who never recovered and never returned to work. The burden for requesting the reopening of closed medical benefits is on the injured worker or their representative. The vast majority of these requests will therefore come from the worker. In rare instances, it is appropriate, and you as an insurer know that the right thing to do is to keep the medical benefits open. To attempt to streamline the process and to be able to arrive at a reasonable decision with the minimal amount of information, the department designed a petition form for the injured worker to complete. If the worker completes this form and provides all the information on the form, even in the event that no medical records are provided, it is envisioned that a decision can still be made. There will be times when you, as the insurance carrier and adjuster, know that the right thing to do is to reopen the closed medical benefits. This being the case, the statute envisioned a streamlined process in which both parties are in agreement and can agree to the reopening. The department developed a joint petition for this event, and following the direction of the statute, will have the review be by the medical director only rather than by a full physician panel. Also, both forms were designed to allow for the written permission by the injured worker for the release of medical records. This streamlines the process and minimizes the back and forth between the department and the injured worker. By signing the petition to request the reopening of benefits, the injured worker is also giving permission for the release of personal medical information to support the petition. This is the start of the process. There is a review to determine if there is a valid petition received, that there is no evidence of excluded conditions being present. The insurer is notified in writing. The insurer has several responsibilities in the process. The insurer needs to let us know if the claim has not been accepted and if it is just being paid under reservation of rights. In addition, the statute specifically states it is the responsibility of the insurer to provide the medical records to the department's contractor. Given that the statute gives a hard and fast deadline for decision-making, 60 days, the department determined in its work process that it absolutely needs the medical records that are already in the insurer's file within 14 days of notification. In this era of electronic medical records and electronic medical record storage, the request for 14 days processing was thought to not be an unreasonable request. It needs to be understood by the insurer that if no medical records are provided by the 14-day deadline, the petition will move forward with the information that the department has on hand. Please remember the preponderance of the evidence will be used. If the only information that is provided is what the injured worker has provided, then that is what the decision will be based on. The notification letter will contain several action points needed by you, the insurer. If the insurer's responsibility to notify DLI if this is not an accepted claim. The medical records from the past 2 years need to be submitted. Choice of medical director or full panel review needs to be made. If the worker has already chosen the panel review option, the letter will also notify you, the insurer, of the injured worker's choice. Remember, you as the insurer have 14 days to send the last 2 years of medical records, and it needs to go to the contractor for processing the medical records, which is Maximus. It can be sent either physical mail or electronically. Please remember not to send the medical records to ERD. It will delay the process. Maximus has a secure file transfer portal that is called Move It Exchange. To access the Move It Exchange, open a web browser to the above address and sign in. As first-time user, you will need to establish an account and a password. When accessing the site, you may be prompted to install an Upload/Download Wizard plugin. This plugin works with your browser to help users quickly upload large or multiple files. ERD encourages users to either submit the requested medical records either via the secure portal or via fax. There is a physical address for Maximus by contacting us at ERD. We do not encourage this as you, the insurer, have only 14 days to submit the requested records. Using physical mail could lead to unnecessary delays. The final determination and report from the ERD will include the information listed on your screen. Notifications of reopening of medical benefits will be made in writing, and the insurer will manage the medical benefits in compliance with statute and rule consistent with the utilization and treatment guidelines as was done before the closure. If there is a disagreement with the decision to reopen medical benefits, this disagreement is subject to the jurisdiction of the Workers' Compensation Court after the process of mediation. If you still have questions regarding the reopening of medical benefits, please feel free to contact us at the Department of Labor and Industry at either email or number listed on your screen.